We also asked them to amend or issue add a comment to Rule 8.4 that would authorize a lawyer from owning and operating or using medical marijuana if the lawyer reasonably believes that conduct would be authorized under the law. The court took a little bit of a different approach. They added a new subsection to Rule 1.2d and said that a lawyer can only counsel or assist a client in conduct that is expressly permitted under Ohio's medical marijuana law. And that follows a split among different states. Some states have gone the reasonably believes route, and other states have taken a more restrictive approach where the conduct has to be expressly permitted under the law. And what that means is if there's uncertainty about whether a client can or can't do something under the law, the precise thing that they go to the lawyer for, you as a lawyer need to be really careful and make sure that you're getting your answer right. Because if you're helping a client do something that is not expressly permitted by the law, you could run afoul of this new 1.2d, even if you have the reasonable opinion and belief that you're right. If it turns out you're not, you might be in hot water. And here are some examples of states that have taken the various approaches. Under Rule 8.4, a lawyer can't commit an illegal act that reflects adversely on the honesty or trustworthiness, and he can't engage in any other conduct that adversely reflects on the fitness to practice law. Whether or not a lawyer can own these companies or use medical marijuana is still completely unsettled under Ohio law. They did not clarify this in their advisory opinion, and there's a split amongst other states. Some states, like Washington, have held that a lawyer is free to own a marijuana business. Other states, like North Dakota, have gone the other way. There are some, and Steve, I'm going to finish up super quickly. Give me like 2 more minutes. The Board of Professional Conduct did note that even if a lawyer violates the criminal law, they're only professionally answerable for things that demonstrate a lack of honesty or trustworthiness. And so the question is, does using medical marijuana have the required nexus between the lawyer's honesty and trustworthiness? What the Board of Professional Conduct said is that one violation of the Controlled Substances Act probably doesn't violate Rule 8.4. But if you have multiple violations, what they call an indifference to legal obligations, then you might violate the rule. And that puts us in this uncomfortable position that if you go get stoned at a Dave Matthews Band concert, right, you might not violate 8.4. But if you're a chronic pain patient and using medical marijuana daily to manage your chronic pain, it's unclear whether you're at risk of violating Rule 8.4. There are most of the examples of 8.4 violations in the context of drug abuse have other aspects to those cases that I think are really important when you talk about a Rule 8.4 violation. For example, in the Stark County Zimmer case, the lawyer didn't register, he didn't respond to the allegations from the board, and the case came from when he crashed his vehicle, he flees the scene, has multiple bench warrants issued, and didn't cooperate at all with the disciplinary process. That, to me, is a lot more like an indifference to legal obligations than managing some type of chronic medical condition. But again, totally unsettled. I'll skip that one. So we're running out of time. I want to talk about sort of 2 cases, and then we're going to do a quick rundown of some other rules that you need to think about in addition to these 2. There were at least 2 cases of lawyers being disciplined out west for their involvement in the cannabis space. This guy named David Furtado, basically the allegation is that he was helping his clients commit fraud against Wells Fargo, where he was taking their money, depositing it in his trust account because he knew that Wells Fargo would not service cannabis clients. So he was holding their money for him, right? He ended up getting charged with money laundering because they found almost $500,000 in cash in the trunk of his car. The case was dismissed, but they kept the cash. Jessica McElfresh was a lawyer out in California, and she had a client that was being investigated for some regulatory violations. And there was this allegation that she was sort of part and parcel in helping her client violate these rules. She again was indicted with money laundering and fraud charges. When they showed up at her house to execute a search warrant, her iPad was in a bowl of water, right? The investigators thought she's trying to destroy evidence, and she thought, oh, you know, the allegation was basically like, oh, her mom like dropped it in the bowl of water, and nobody took it out. So be very careful when you're working with these clients. Some other things to think about. One of the first rules is competence. The old notion, jack of all trades, master of none. These clients deal with a lot of different legal issues. If you're at a firm and people at your firm can help, get them looped in. If you need to go to outside counsel, bring on other lawyers to deal with particular aspects, please do it. I do it all the time. Malpractice insurance. Be comfortable that you are going to be covered by your malpractice carrier for advising cannabis clients, because you have an obligation to notify your clients if you don't have malpractice coverage. Your IOLTA account. We've talked about banking issues with cannabis. Be comfortable that if you are taking a retainer from a cannabis client that you're not going to get your IOLTA shut down, because then you're in a really bad position, because you're going to be stuck with all this money and you got to notify your clients. That could potentially now get reported to the board because your IOLTA is shut down. Is the bank going to think that you're being disingenuous, et cetera, et cetera, et cetera? Think about conflicts, especially in a state like Ohio where we have competitive licensing environments. If there are 12 cultivator licenses being awarded, can you work with multiple clients? How many can you work with? What do you need to disclose to those clients about the fact that you work with multiple clients? How do you manage your duty of confidentiality and loyalty to each client where they're competing against one another? And finally, think about how you charge your clients. One of your clients is going to say, what if I just give you a stake in the company and then you don't charge me? And then that way, if I win a license, you may have done $50,000 worth of work, but it's going to be a $5 million company. Is that an excessive fee? If you're getting paid with equity, you know, that's $1 million for doing $50,000 worth of work, what if the client doesn't make a distribution to you, you know, when they sell that company or when they have that profit coming in? How do you enforce that? How do you go to the board, you know, or go to the bar association or file in court and say that client owes me $1 million because I did $50,000 worth of work? And do you really want to be in the position of suing your own clients to enforce those obligations? So that's all that I have. I was worried I would not fill up an hour and a half. It turns out I've gone over. I will stick around for a little bit in the back. If anybody has questions, I'm happy to talk to you. Please don't hesitate to call me, email me. I love talking about this stuff, and I'm happy to help anybody as much as I can. So thank you all very much.